Lordship, I beg to mention item number 6, Your Lordship. With the consent of other side, Your Lordship.
Item
Item number 6, Your Lordship.
6.
Item number 6.
Yes.
So the state has filed a petition for conduction of delay, Your Lordship. But I don't have the objection, Your Lordship, because I have some personal difficulty because I need to leave, Your Lordship.
Okay. So we can allow this condonation application.
Lordship.
Okay. File. Item 6. Heard. Mr. S.H. Boran and APP for the state, as well as Mr. A. Devan, learned counsel appearing for the respondent number for the respondent. By filing this interlocutory application under Section 5 of the Limitation Act, the state has prayed for condoning the delay of 68 days beyond the period of limitation in filing the connected connected criminal leave petition, as well as the connected appeal. Against judgment and order dated 14/10/2022, page 1, passed by the Lord, additional censors, so, comma, thereby acquitting the respondent who was charged for committing of offences under Section 341, 366A, 376 IPC, read with Section 4 of the POCSO Act. Next one. Although the learned counsel for the respondent has objected to the prayer made in this application, but considering the fact that the state has filed an appeal against the order of acquittal and taking note of the reasons assigned in paragraph 12 of this interlocutory application explaining the delay, the same is accepted at good and sufficient cause, which has prevented the applicant to file the connected appeal on time. Accordingly, the delay of 68 days beyond the period of limitation in filing the connected appeal, and as well as the criminal leave petition stands condoned. So this application stands allowed. You give copies of criminal appeal and this leave petition to the this will be in criminal leave petition in view of order passed today in I criminal 276 of 2023, by which it said interlocutory application for condonation or delay was allowed, list this criminal leave petition. When do you want? 4 weeks. No, no, when we are continuing the delay, 2 or 3 days.
2 weeks. 2 weeks.
No, no. We'll fix it up next week, Friday next. Because no point continuing the delay and then again causing delay. Correct. Because here the court has given 2 findings. First is that there was consensual relationship. Second finding is that to the effect that the girl was not a minor at that point of time. That are the 2 basic things I have noticed. Although I did not read it thoroughly. List on. Friday? Oh, okay. Friday will be 23rd.
Flexible. I'm mentioning an appeal, my lord, for hearing on next Thursday, my lord. Pending for.
Hearing, it goes to March because we are taking up a day-to-day hearing. Not this month.
Then, my lord, March, may I pray?
Give it to the court master. They will make adjustments and take a date.
Daily list, item 1.
Yes, come for the first time.
First time.
Okay, Mr. L.R. Mazumdar, counsel to the applicant. Again for the first time. Notice returnable in 6 weeks. Give a date after 6 weeks.
Mm-hmm. 10/4.
Jurisdictional magistrate. Call for the admit, call for the records. Each of the application shall be considered on service of notice on respondent 2 and receipt of LCR.
Online.
Objection, if any, by next week, by next date of this thing. Objection, IA.
Online.
Item 2 for orders.
Yes, pardon me.
I have received the paper book, Lord.
So it will go for hearing,
Yes, Lord. I have received.
just on this. Is convicted of 302.
Yes, Lord.
But this as Kanpur and Council, and amicus curiae for the appellant, and Ms. S.H. Varal and APP for the state. As LCR is received and paper book has been prepared, list the matter for hearing in the month of March 2024. Yes, item 3.
Item 3 to 5.
Lord, we have not received the paper book.
Okay, Miss
On behalf of Mr. Aditya Lukha.
P. Saikal and counsel for the appellant submits that she has not received a paper book in the matter. For the other items, item number 4, you have also got it? No. You have got it? So, Ms. T. Begum, amicus curiae in item 4. Not pleased with paper. Mr. Ganguly is not there.
Lord. He's not there.
The registry can provide a copy of paper. You have got it? Shall provide a copy of paper to the council for the applicant. List up to 2 weeks. Get the paper book, then we'll fix a date for hearing. In, don't appear like that. You know how to button up your collar. Don't come shabbily. We don't see you.
I'm there.
It's okay. Whoever is there, but we don't see him.
Item 7.
Item 5, none appears on call. The registry shall ensure that the photocopy of the paper book is served on the learned amicus curiae. Same 2 weeks. Item 3, 4, 5 together. Item 6 is already there. Item 7.
Item 7.
Yes. Mr. Ganguly, you got the paper book? Okay. I take recording presence. Mr. Ganguly, amicus curiae. Yes, item 7.
I was the coordination of the.
Coordination of delay. None appears on call for the legal aid counsel is absent on call. You should notice on this application under section 5 of the Limitation Act for condoning the delay of 101 days beyond the period of limitation in filing the connected appeal. No, something is wrong.
Condemnation delay of 75 days.
It is noticed that in the cost title of this application, the delay of 101 days till 25/1/2024 has been mentioned. First of, however, this application but as per the filing seal of the court, this interlocutory application as well as the connected appeal was filed on 13/2/2024. So therefore, the reference to 101
Not in filing the criminal appeal.
No, but you have given 101 days till 25 January. That is not appropriate. You file it, you'll have to show it. We'll take it up at 2 o'clock. There is discrepancy in the filing slip as well as the filing seal. They'll have to explain because in continuation of delay, there should be accurate calculation. We'll take it up at 2 o'clock. We'll sending it for the registry to examine it. Because if this is happening in one matter, there's every likelihood then every matters this type of mistakes are occurring. Because so far as in the bench I am concerned, I am trained to look at the filing seal. Correct?
Right.
At 2 o'clock.
Item 8.
I think
87 days. So notice has to be issued. What is the section under which is the 302? Okay. for Mr. J. Das, Learned Legal Aid Counsel, appearing for the appellant, and Ms. N. Das, Learned APP for the state. Next, you should notice on this application under Section 5 of the Limitation Act for containing the delay of 87 days. You have the period of limitation. Same thing, right? Same thing. 7
Gap into date of filing.
15 to.
That's the discrepancy. Because he has to explain in the date of filing. If the seal of government, the seal is always.
Same also, yeah, there. Mr. Das will take it up at 2 o'clock. Here also the same thing. Filing seal is of 15/2. The acknowledgement slip is of 8/2. The explanation of delay is till 7/2. At 2 o'clock, let the registry explain. Ms. Baran, Ms. Das, what is your experience in these matters about condemnation or delay?
Aware of what is going on, what is happening in registry lordship. This is the official matter, I suppose.
No, because you see, if you look at it dispassionately, supposing you are the recipient of a notice. In the affidavit, you find a date, let us say 25th January. And you find that the delay expiration is till X days. Now, if I'm expecting you to respond to it, how do you respond? Say you are a villager, you don't know the legal procedures, you get this notice. In the affidavit, you find that the affidavit is sought on 25th January. Filing here is on 12th February. So explanation of delay is still here. So when you do the calculation, you will not be able to understand
Yes.
what is the procedure or how the calculation is made. What should be your reply?
Lordship, from the date of receipt also.
No, that's okay, but explanation, the end date is what? You file it on 1st of January. Filing slip is of 2nd of January. Affidavit is of 31st of December. Now, when you receive a notice, how will you respond?
So there is some discrepancies, I think. So we have to-
I'm asking you because you deal with it day in and day out, condemnation or delay. Because this is the first time we have noticed this discrepancy. Supposing you get a notice, how would you respond to it? As an advocate also, if you get a brief,
Lordship.
how would you respond to the calculation of delay?
Because we have to give us some good reasons and cogent reasons. We have to explain that.
No, you are respondent, you see. You are respondent. Now you get a brief. My question is, how would you respond to it? How do you draft an objection?
We generally calculate the date of receipt till date of filing.
Now, in this case, what would be the date of filing? 31st is the affidavit,
Lordship.
first is the filing slip, second is the seal.
So seems to be a.
Seems to be something wrong.
Yes, something.
Okay, Mr. Das, it's okay. Mr. Das, you may leave, we are not detaining you. Yesterday you told us, no issue with that. You had some difficulties at appearing today.
Somehow I managed it because the last court, I have to hear him.
Okay.
I just gonna say, Malak.
Okay,
Uh,
we are
okay.
sorry, but since we are continuing with it, I thought that we should wind up, otherwise,
No, quite, Malak. Let him complete it, I'll just complete my, because I just formulated my points, it will be easier, Malak.
okay,
It will
okay,
be easier,
okay.
not going here and there, jumping from here and there, just concise to the point.
Okay, okay,
It will not be-
good. We'll take it up at Mr. Das? No, to Mr. J Das. We'll take it at 2 o'clock.
Supplementary item 9 to 21.
But we are sorry, Mr. Das. We are sorry to make you work on a.
That's- Congrats, Malak. I'm a lot. Look. Hello,
Yes. Uh, Mr. Mishra has made an argument. He was referring to that 48 hours money was lying for more than 48 hours. This is contravention of which provision of UAPA?
48 hours.
46, 48 somewhere, I couldn't. Because I forgot to write that.
Section 20. If I recall, that is section 27.
27.
But subject to, I'll just read out because that's what,
No, check up because
issue of notice, notice before forfeiture of proceeds of terrorism. That is section 27. No order for any process shall be made, unless the original. 29.
no, I don't think for 27.
Milord, section 25, I'm sorry,
25.
25 2, Milord.
25 too. Correct. I forgot to write it, that provision. Just a moment, there's one more gap. This Sinan Gune Singh. His accused number
Sinam number
Sinam, SINAM,
A11.
A11. This evidence of PW5, you were referring, it is page 36 and 37 or which volume? Evidence of PW5.
Accused number 5.
PW5,
PW5.
that is at which page of the paper book? 36 and 37, but which paper book?
Third.
It is at page 36 and 37, but which is the volume, which is the paper book?
Oh, PW5.
PW5.
117. 117. Will be part 1, volume 1.
Part 1, volume 1. Which page?
170.
170. And the list of officers is at page 36, 37 of which volume?
But, part 2, volume 1, page 17.
No, I have recorded page 36. If it is page 36, either it's Mr. Mishra's compilation,
Maybe, but as per the course paper book, it is in page 17. Part 2, volume 1. It will be more specific if I mention exhibit 5.
no, just a moment. Okay, and I now get it. It's page 36 of this compilation, but it is page 170 to 176 of the of volume 1. 170 to 176.
No, that is a photos, but please specific names where Lord will find the names of Lieutenant Colonel Major. There will be page 17, the same volume,
Okay.
part 2, volume 1.
Oh, just a moment, just a
exhibit
moment.
5 2.
Page 17, volume 1, part 2. Okay. Just a moment, there are a few gaps. Let me.
79.
Yes, this and Dilip Singh, his accused number
Case number 16.
16. Who is the witness who said that this printout of emails were in Meitei language? How do you spell it? Meitei? Mite?
Mite or Mite?
Mite or Mite? Okay. Mite, who's that PW who says that original mails were in Mite language? Is it PW 53? Satish Chand.
This done.
Somebody said that it is in Meitei language. He also said that this emails were translated by assistant professor at Bangalore. Is it PW 53? No, 53 did not say that. PW 74, 79.
Translated, it is not there. It is only certified the translation.
Okay, I think it is PW 79. his evidence is that the email ID is greenfield006 yahoo.co.uk. As per the instructions of CIO, the emails exhibited as so and so were personally taken by me to Bangalore in order to get it authenticated for its true translation from Manipuri to English. That means original was. Okay. Yes.
But, I'm on accused number 25 H Bone Jersey. Today's item number 17. And criminal item number 295. Not he was,
Now you are criminal appeal number
295.
295. Yes. Yes.
Accused number 25 A Ibom Jersey.
Ha, Imam Shah.
He was convicted under
20 and 21 for 7 years. He served out the sentence. And he was arrested by NIA after they took over Nurmati PS case. And he was arrested in the year 2011.
7 years. Now,
Ah.
before I take Milord, his other evidence, Milord, may I respectfully take Milord to part 1, volume 5, if there's no.
Part 1, volume 5. Okay.
Milord, kindly opening case 989.
89.
989.
989. Okay. Yes.
Para 83 of this particular case, Milord will find the right. It was therefore clear that the prosecution have been able to prove beyond all doubt is A5, A6, A7, A8, A9, so and so, so and so. Now, A23, A24, and A24. How do we read this? Just how do we read this? And they have not gone for horizontal. I'm accused A25. They have not filed it, they have not preferred an appeal. They have not corrected also. How do we read this? A24? Because the allegation is that I've been involved with adjustment. How do we read this? And in that case, if we go by this paragraph, am I convicted under 20? Just because I have preferred this appeal, it's also mentioned that all the accused are convicted under section 20. But specifically, my name is not mentioned. How do we go about this? Now, under section 20 of all the accused are sentenced, that is, Milord will find again in para 96, page 993. Am I convicted under 20? Or I'm not, whether I'm convicted? That is little confusion there. Therefore, I have preferred this appeal also. And till then, NIA has not given any rectification or correction to this FIR. Am I to be read that I am convicted under 20? No.
The time tested English proverb, read between the lines.
So the very
Perhaps, perhaps you can't read between the lines. Okay.
Go by that, whether the benefit will go in favor of accused. No. This is the mistake. It's a very major mistake. And this mistake will definitely go in my favor.
Okay.
And my lord, just while referring this paragraph,
No, in the preceding paragraph, that is in paragraph number 82 of the judgment.
yes, my lord.
In the last line, it is categorically mentioned. Now, read last line of the paragraph.
Yes. Responsible for such, but there's no finding on that, no, my lord, again. If we go to preceding paragraph.
No, there is a finding, last line
Hmm.
of page. Para 82.
Only indicate is considered overground outfit of UNLA. And indeed members of UNLA.
Yes.
Yes, indeed members of UNLA. Now, while coming to that, now another my lord, just for a reference, my lord. There's an accused, my lord. Accused number 9, my lord. Accused number 9, well, he has no evidence, my lord. He has no preferred evidence. Accused number-
Just a moment. CRPC. That's CRPC. Come to page 465. Sorry, section 465 CRPC. Finding or sentence when reversible by reason of error, omission, or irregularity. Subject to provisions hereinbefore contained. No finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation or revision on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceedings before or during the trial or at the inquiry or other proceeding under this code, or error or irregularity in any sanction for prosecution unless the opening court or failure of justice in fact has been occasioned thereby. So you see, number one, this error of referring to A25 is cured by this statement made in paragraph 82, where it has been specifically held that A25 was indeed a member of UNLF. So that finding of fact is there. So refers to A24 in the subsequent paragraph of 83, you'll have to explain to us that this really has caused any prejudice to you. That is why we are referring to 465.
This is.
No, you take your time. It's not necessary. You can respond immediately.
I'm referring this without, in this, all the, every sentence in mark without, just for reference, I'm bringing this. But not in this particular file. In this particular file. Again, my lord. There is an accused who is accused number 9. He has not preferred appeal. He was given 7 years, he completed the sentence. His language behind the bar, after completing the sentence, yes, can go out. Why I'm making the reference of this A9 method? It may be relevant or it may have bearing or it may not have bearing. That is, I leave it to the wisdom of Lord similar. At least just for the reference. This accused A9. That particular Lord. Page 17 of paper book, part 2, volume 1.
Part 2,
My lord.
volume
1.
1. Yes. Yes.
My lord, if your lordship kindly come down to serial number 11 of measure
Page
17.
17. Yes.
My lord will find one name, serial number 11, Major Maibam Chaurel, 175.
Yes. Yes.
Now, if I reasonably take your lordship to page 114 of the same volume,
Yes.
same 175 Maibam Chaurel. Yes, Milord. Have you also noticed that? Now, just, I'm sorry to trouble you, Milord, part two, volume five. I have to just compare these photos, part two, volume five. I'm sorry for troubling Milord.
Yes.
Page 119. Page 11119.
1119.
1119. Dot, form, triple.
Yes.
Milord, photograph Q4, question number 4, photograph of Major Maiban Saurel. Now, the simple so and so, and his photograph, Milord will find in page 1121. Now, his accused number 9, they have found the same photograph. It was all compared, but he has not been accused, convicted under 121A and 18. That's what I just wanted to point. Rest of the accused,
I'm sorry, I didn't follow you.
question number 4, photograph of Maiban Chaurel. Milord will find his photograph in page 1121.
Yes.
That right bottom. He is accused number 9 in this case.
Yes.
But my lord, just he was convicted only under section 20, but not under 121A and 18, my lord. The same set of evidence, same set of photographs, same set of comparison. One is convicted, one is not convicted, but just wanted to point. I just wanted to point it out. That, my lord, you, as he's not in appeal, I'm not going further, my lord. Just for your lordships, yes, not this man. I'll come to inform sir now. Accused 9 has been convicted only under section 20, not under 18 and 121A. But the rest of the persons are convicted under 121 and 18. Whether how the manner of appreciation of evidence, look, the evidence has not been appreciated properly in this case. And they have not gone for appeal also, my lord, under 21(4).
No, interestingly, since I have been giving examinations in schools and colleges, whenever I sat in the examination, the results were never out on the same day, on the appointed day. Supposing they say that results will be out in 2 months, it never came out in 2 months. So I had a feeling that perhaps when I write, many more experts are to be consulted, then they understand what I am writing. So that was the impression I always had. That I was very smart. My writings, a single individual could not understand. So it goes to various authorities and then they understand what I have written and then they give me marks. Second impression is that they keep boxes in front of them and throw papers. So wherever it falls, I got that mark. Same thing has happened here. So after everything, there was a toss and then conviction only under one provision. The toss is the best, one of the best scenes in the movie Sholay.
In one way, other way, what I want to say, in his submission, what we get, he admits this photograph of Chorel. Somewhere the court has not confirmed, but he admits that Chorel is there. And his name is there in page number 15, that officer's list. But in spite of being his name there, He's not been convicted. But he admits.
No, he's not admitting. He said he has questioned it earlier. In his earlier argument, he has questioned that the emails were not proved in accordance with law. So he is,
But email is not true here. In that case, email is not true. Look, I'm coming to 825. Now this, because as they have not preferred appeal, let it rest. Uh, 825 Milord, PW number 23.
just a moment. He was convicted in 121.
21 and 20.
This Maibam Choral.
No, he is not
Children
convicted.
only 20.
Not convicted. Under 20 members.
Only under 20.
He means, Maran, he means to so that Spanish name is there, he has not been convicted. That's what he means.
So basically, perhaps he's arguing on parity, that if from same set of evidence, if only one is convicted only under 20, why others can be convicted under that?
Right.
Yes.
PW number 23. That Milord will find in work, part 1, volume 1. Milord, case 222.
Just a moment.
Volume?
Volume 1, part 1. Milord, the BOMSA was associated with Aegis. That is what the prosecution has said. Now, Aegis is a cooperative society. Aegis is a cooperative society. Now, the allegation of the prosecution is that this Aegis is being funded by UNL. Therefore, Lord, well, so far 83 per 82 is concerned, it can be taken care of by section 465 that your Lordship has said. My Lord, let it go in that manner. I'm convicted 20 and 21 for the time being. Now, PW 23, my Lord, is a bank manager. AK Ibo Chobasi. But what is serious? Today, I have appeared before the court on receivable summons. I have been working with Imphal Cooperative Bank since 1974. I retired as general manager of the bank in the year 2011. During that period, I had been working in the bank with different capacities. Association of Extensive Growers, that is Aegis, is a registered firm of Imphal having account in our bank. Exhibit 40 is an application by the Secretary Aegis to the branch manager of the bank for opening account along with the said application so and so, as is held on 26 and containing the signature of N. Bhumi Singh in 10 pages. Bhumi Singh is also a convict in this particular case, but my lord, he has expired during this pendency of the under. He was suffering also. He was also out on bail on medical ground, my lord. In 10 pages with his signature, President Y. Brajapidu Singh, Secretary and Bhumi, Treasurer A. Bumsa. I'm the treasurer during that relevant point of time. Is it certificate of registration and account opening containing so and so. The agents applied for loan of rupees 50 lakhs. That is very important. Agents applied for loan of rupees 50 lakh, which was sanctioned by the bank against 3-term deposit, of which party submitted into the bank of rupees 2520 and in all 65 lakhs for securing the loan. The party thereafter repaid the full amount on 16/8/2005 by adjustment of the term deposit within a period of 14 days. Exhibit 50 is the loan account statement for the period of so and so, signed by the manager so and so, which identify. Exhibit 5(1) is a continuing security letter given to the manager of the bank by the secretary so and so, the demand so and so. Now, when it was put on cross, now exhibit P3 are the paying slip by which edges deposited. These are the amounts which edges deposited after securing the loan. Now, at the time of the loan transaction, which I mentioned in my examination in chief, I was not an administrative officer of the bank. I was working as a manager of Lamlong branch. One Lukhoi was the general manager of the bank at the time. Said Lukhoi died about 1 year back as he suffered from cancer. All the accounts and transactions of the bank are audited and inspected by the Reserve Bank of India and the state auditors of the state government. There was no adverse comment from the state auditor, including the RBI, as regards to the above mentioned loan transaction. I produced a document exhibited during my examination chief to the agency as by it after I took over the charge of GM of the bank. I have no personal involvement in the said loan transaction. The nature of the transaction of said loan, that is sanction of so and so on 37/2005 and the closing on by the adjustment of term deposit is permissible within the norms of the bank. Why Brajapidu and Bhumi are good customer of the bank and all of them are reputed businessmen. Undoubtedly, these 3 persons are all reputed businessmen of Manipur. So they were operating the adjustment. Now, if we go by, they said it's a process of terrorism. Section 21, that's where I'm convicted. Now, what is section 21 of UAPM? Now, I'll just read a little small. Slowly, I will. Whoever knowingly holds any property derived or obtained from the commission of a terrorist act whoever knowingly holds any property derived or obtained from commission of a terrorist act or acquired through the terrorist fund. My lord, there are 2. One is that the particular property has to be derived or obtained from the commission of a terrorist act. But in this particular case, my lord, there is a clear-cut finding that there are no terrorist act in para 84 of the judgment. A clear-cut finding. Now, or acquired through the terrorist fund. Now, my lord, my learned senior also has taken to that particular para 84 many a times that there are no terrorist acts. So for this trial is commission.
That is para 84.
The judgment.
That is at page
990, my lord.
990, part 2, part 1, volume 5.
no terrorist act. Therefore, not only to that extent, my lord, here, in this particular case, accused A5 to A19, including A19, who is the chairman of UNLF, so far the prosecution case is concerned, that they are not held guilty for terrorist act. Not even a single person has been held guilty for terrorist act in this case. So from where that this fund will come under section 21. Well, section 21. Section 21 has clearly mentioned that there has to be a commission. Who even knowingly holds any power derived or obtained from commission, my lord. There has to be a certain act of terrorist act from where this fund has to be derived or obtained. So there is no commission of terrorist act. Section 21 goes, or acquired through the terrorist fund, through that terrorist fund of that act, my lord. Even though we don't go by the evidence, my lord, by the finding of the lower court, by the special court in para 84 itself says that when there is no terrorist act, commission of terrorist act, or through that terrorist fund, no, my lord. Then from where this fund comes.
But one of the witnesses has said that he is a businessman, he is a contractor and has to pay 30-40 lakhs to the terrorist organizations. He has said that.
Wait, terrorist organization. Terrorist, but here, the charge is under one particular terrorist organization, that is United Nations Liberation Front. It's not specified that. They said there are a lot of imposters also, and in the name of terrorist organization, there are a lot of imposters. There are other evidence also.
But you've seen today's newspapers. You've seen today's newspapers? No. In Manipur, due to demand of funds, today all what you call
no,
petrol pumps are closed.
Yes, that petrol pumps are closed there. That not, I've seen in that this thing, online news. So now the question is, that is what apprehension in that they are having in Manipur. Because of demands, and Milord might have seen, so many persons in fatigue dress, that commando dress, are roaming around in Imphal Valley and hill areas. And the central government is closing their eyes. And we ask, are they terrorists? Are they volunteers? Are they village volunteers? Are they patriots? Nobody knows, beloved. That is the very chaotic position that they have kept Manipur in that manner. Since May 3rd, my lord, everybody is suffering. Not only to that extent, my lord, off the record, even the judicial officers are not invalid. Those judicial officers belonging to Kuki community, police officers belonging to Kuki community, judicial officers belonging to Meitei community, and police officers belonging to Meitei community. From Kuki area, they have come to Imphal. Even the judicial officers from Imphal area, they have gone to Kuki area. And even the staffs of the High Court has been transferred and they have been managed in other session court in Kuki area. That is the situation in Manipur. Even the judicial has been affected. The staffs, all the Kuki staff from High Court has gone, because I also sometimes go to Imphal, I know. They are not judicial officers. So every shifting, my lord. So that is what is, not only that petrol pumps are closed, government, central government, state government, and the high court has to go to every relief camps to distribute blankets, charcoal, mattress, led by Chief Justice. Even the High Court has come down to that, my lord, even to have the people. Every week, almost they're visiting the relief camps to distribute items.
No, but the point is that this witness has proved that he is paying money to the terrorist organization.
But terrorists, he's saying that I'm paying money to terrorist organization. How can it be legal with a terrorist? Because the specific link is that the terrorist fund of UNLF, that has to be from UNLF. There has been clinching evidence in that regard, that this particular agency is being run through a terrorist fund, from UNLF. Because in Manipur, Milot, in Assam, we find Alpha, this thing, in and for Karbi, for Daisy Dam. In Manipur, Milot, we have got more than 35 underground organizations. And only in Kuki community, they have got 26. In Meitei community, we have got more than 50. Every third, in a sense, every third person is Holland. We can say,
Okay.
that the operation of more than 40, 50 organizations. Some are listed, some are not listed. And the businessmen happily, they say that whenever something comes, whenever they think, oh, my money has been demanded by terrorists, so that I don't have money now. That also another way of giving excuse. I don't have money, it has been collected, exported by terrorists. Whether that has been collected or not collected, nobody knows. So one accused, one PW, I believe, he has said that they have to pay 30, 40 lakhs. To whom? To whom?
Who was that witness?
NG Robert. PW 39, then my lord will find in page part 1, volume 2, page 265. My lord, PW 39.
Yes.
My lord, if your lordship kindly open it page 266 in the cross part. He has said two things. Page 1, it starts from 265, it is 266. PW 39. On cross, my lord. On cross, first para, my lord, the third line from the bottom in the cross, that my lord will find in page 266. I cannot say that any of the members of UNLF cadres demanded money from our family members as well as farm. He has categorically said UNLF has not demanded. But it is not a fact that we never paid 30 to 40 lakh here, but however he pays, unlawful organization. The trial is of well, even it says in our visit, second, I do admit that the underground organization who demanded money from unknown person, I have no idea about their organization as well their identity. Then lords, my lord, at least, my lord, when more than 40 underground organization, my lord, are operating, my lord, they say, but the trial is for UNL. There are a lot of imposters also, my lord. That's one of the witnesses that there are a lot of imposters. But on presumption, my lord, one cannot be convicted. There has to be clinching evidence in that regard. The specific allegation in the charge sheet is that Aziz is being funded by UNLF. And nothing has been done in that regard. Having said that there are no terrorist act, the first part goes. That particular money has to be obtained and derived from the terrorist act, it goes. Number two, that terrorist fund has to be the commission of the terrorist segment. And terrorist act has been defined again in section 15 of your PMLA. Where my learned senior has dealt for 2 days, where I don't need to revisit again. And the Lordship is quite aware of the fact how the evidence has to be appreciated. My lord, now P23 has said that loan was taken, 50 lakhs loan was taken, and it was returned within a span of 14 days. Now, it is permitted by RBI. And there's nothing wrong in that regard to return a loan within a span of 14 days, as per the term that the loan was taken. And moreover, he has said, all these 3 persons, Reservito, Omi, and Ibumsa, they are renowned businessmen of Manipur. Milord, now they have also relied on PW24 that Milord will find in page 224. He is a CA, chartered accountant, Rakesh Kumar Jain, PW24. Milord will find in page 224 in the same volume, that volume 1, part 1. My lord, I'm practicing in Imphal as chartered accountant in the DK Bora and Company located at Imphal. I have been practicing since 2001 and till now I'm in this said company. We have different clients coming to our firm for the purpose of auditing their assets for the purpose of taxes, and accordingly the firm on payment of fees audit and their assets and submit their return. Among the clients, we also have associates Aegis as our client, And the firm had audited their account in the year 2005, 6, 7, 8, 6, 7, and 7, 8. The firm produced documents and books of accounts, and for that purpose, their secretary Bomi also come to our office. On behalf of the firm, I also visited Aegis at Mantri Pukri. We filed for the purpose of verifying, and I found that one of the machineries was installed and the work set was under construction. The accountant after production used to take back the books of accounts and other documents, and I found that some of the contributions were not supported by proper documents, and I advised the said transactions should be through bank with proper receipts and should be supported by the bank statements. I also noticed that there were loans of bigger amounts taken by the firm, but I found the bank statement does not reflect repayment of the loans. After my advice, the judge did not come to our farm. After 2000 SS, I cannot say how they have managed the farm. Exhibit 55 are the set of documents which are the party submitted in the course of auditing. Exhibit 55 is a seizure memo which accounts so and so. Now, next page. Exhibit 50 is a seizure memo by which one receive a payment account of Aegis with effect from 1/4/2007 to so and so, so and so. Utilization certificate Aegis that is so and so. Exhibit 56(2) are the said documents in 13C. The firm did audit of pineapple processing unit at Matai, and not other audit of the other activities were carried out by the firm. The Aegis has not asked to carry out audit for other activity as such. Our firm did not apply PAN number and hence they had not filed return of the Aegis. My lord, he has mentioned two places, Mantri Pukri and Matai, my lord. These are the same places for your kind information. It's like Guwahati and Ulubari, something like that. Mantri Pukri is a whole area, Matai is that particular village that falls under this thing, post office jurisdiction of Mantri Pukri. I have no relation with the farm Aegis after the year 2008. None from the said Aegis came to office. There are others CS practicing in farm. The farm Aegis is a registered society and carrying on its activities under its bylaws and other regulation about the central and the state government. I have come across certain documents between the Union government and the Aegis regarding equity, subscription, subsidy, etc. concerning the food processing unit of the Aegis. The said documents are also produced by me to the NIA, which sees the same. There was sizable financial assistance from the central government to the Aegis. It's even being funded by the central government. And it's on record. Which was transferred to the account by the central government. And this all entire documents were seized by NIA also. Yes, one part is that Aegis took loan. Another part is that it was even funded by the central government and state government. And they are doing the processing unit of pineapple. Now, again, he was called, page 226, re-examination again was done. By Exhibit 56, I handed over 3 documents pertaining to Aegis, receipt and payment of account of Aegis with effect from 1/4 so and so to so and so so and so. Utilization certificate of Aegis dated so and so. Certificate of expenditure of Aegis. Exhibit 56(3) is my signature. Exhibit 56(2) is the receipt and payment of account of Aegis. In the column of receipts, unsecured loan from friends and relative is 8,60,000. The said amount could not be substantiated by the party. Another amount membership contribution in the receipt column of 9 lakhs. The said also could not be substantiated by the parties. The party was told to substantiate the amount by giving particular, but as the party could not give any detail as such, the details were not mentioned in any annexure of the audit report, so and so. Exhibit 56(4) are the said entries. Exhibit 52, the audited receipts and payment account are in 5 pages. Exhibit 56(5) are my signature and initials, so and so. N. Bhumi Singh signed as Secretary Aegis Imphal. During the course of audit, I personally inspected the premises of Aegis at Mantri Pukri, Imphal, and I found some of the material installed and construction work that was going on at the time. I found that the food processing unit has been not yet started. Even the election connection was not commissioned. Exhibit 56 is itinerary so and so regarding 28 lakhs receiving from the Ministry of Food Processing, Government of India. The same was utilized for the purchase of machineries and equipments. Exhibit 56 is my signature and Exhibit 57 is the signature and Bomi, so and so. Exhibit 55 is the audited receipts of the payment accounts for the period from so and so to so and so. Exhibit 55, 350 are my signatures and initials, so and so. 55, 5 and are the signature Bomi as Secretary Aegis. Exhibit 55, 7 is the audited receipts and payments account for the periods from so and so, so and so. Exhibit 58 to 55, 11 are my signatures. Exhibit 55, 12 and are the signature and Bomi sign as Secretary, so and so. In the column receipts, unsecured loan from friends and relatives, 15 lakh. The said amount could not be subsidized by the party. Another amount members in the receipt, 8 lakhs. The said amount could also not be by the parties. The party was told to subsidize the amount by giving particular, but as the party could not give any details, says we are not mentioning an annexure of the audit. Exhibit 55, 15 are the two entries. 55, 6 is audited receipts and payment account for the period so and so. Now, Exhibit 55 is the utilization certificate regarding utilization rupees 28 lakhs received from Small Farmer Agri-Business Consortium. The same was utilized for the business of setting up pineapple unit for the period so and so. Is a signature. Exhibit 55 is the audited receipt so and so. Now, on cross, I passed CA in the year 2001 and started practice as CA from April under DK Bora so and so. I became a fellow associate in the year 2007 after completion of 5 years of continuous association with the firm. I had only 3 years experience in the year 2005. It is true that during the relevant years, no client had approached me individually, but all the clients came through the firm. I denied this and I was so inexperienced to properly audit the accounts of my firm individually, of any firm. It is true that I have not made any written request from the said firm about the details of the accounts of the membership contribution and unsecured loans from friends and relatives. I denied this and that I did not ask the firm from producing particulars or related documents concerning the unsecured loans from friends and relatives and contribution from the members. I also denied this in that I have not audited accounts of the said firm properly. I have not mentioned in the audit report regarding the absence non-fungible of documents by the firm as regarded the membership as well as the unsecured loan from the friends and relatives. The witness volunteers to clarify that. He discussed the matters of non-existence of certain document with the management of the concerned company who told that these things will be taken care of once the company starts production. I denied and that I did not have a so and so. This is what the CS said. The CS said 2, 3 things. He has said 2, 3 things, my lord, regarding financial aid from the central government, even regarding the loan, and some contribution from some membership contributions amounting to 8 lakhs, 9 lakhs. Some contribution from memberships. That is what he said. But this contribution from that membership contribution or this contribution has to be a funding through a terrorist act by a terrorist organization for a commission of that terrorist act. There has to be a commission of a terrorist act in view of section 21. But there are no instances of commission of terrorist act. Not only to that extent, my lord. The trial that was confined of this particular trial, my lord, there are no evidence and there are no materials to support that there was a commission of terrorist act. But my lord will be surprised if, my lord, para 84 not only says that, not just, my lord, Well, not only that. Para IT4 doesn't even end there. The para IT4 also specifically said, my lord, one sentence, my lord, there was no circumstance on record to show that any specific terrorist act was committed on the direction of the leadership of UNLF. The simple finding does not confine to that during the trial or during the trial of this particular case, commission of terrorist act was not found. That in addition to that, there was no circumstances. The judicial finding to that extent, there was no circumstance on record to show that any specific terrorist act was committed on the direction of the leadership of UNLF. Let's assume for that is a finding. Even the circumstance, the direction to commit a terrorist act is not even found. Let's forget about the commission of the terrorist act. Commission of terrorist act is not found, but not even a direction to commit a terrorist act is found from this record of this case. Then how can 21 be applied? Because all the fund has to be from commission of a terrorist act. My lord, in the same volume, I respectfully take, my lord, to page 238, PW 29. Exhibit number, sir.
Every 29
PW 29,
page.
238, my lord. My lord, I have passed my management course from IIPM New Delhi. After completion of my management course, I was looking for some jobs and have been doing small work. Sometime in the year 2006, I came across one Mr. Prem when I was attending a training program conducted by Manipur Food Processing Industries. Said Mr. Prem introduced me to one food processing industry by the name Aegis. I joined Aegis, which is a newly established industry. I was allotted to the duty to assist and supervise the work of Aegis. In Aegis, I came to know one Mr. Haridas Sharma, the president of Aegis, and Bomi, secretary so-and-so, Y executive member, and others. I also came to know that in the running of Aegis, they used to take loans from IUCB, Imphal, Small Farmers Agri Consortium, and Ministry of Food and Processing Industry. In the year 2008, I met with a severe road accident. Then I was bedridden for about 1 month, and I could not attend my duties, and I resigned from Aegis in the same year. While I was working, I was not getting any regular salary. Presently, I have started my own business in medicine. I came to know that the police have sealed the food processing unit Aegis and says it's not running. After the arrest of office bearers Aegis, the police prepared some documents, and I am a witness to the said documents. Exhibit 62 is the personal search memo in respect of A. Bomsa. Exhibit is my signature, arrest memo, so and so, so and so. Now, is the arrest memo and Bomi Singh is my signature. Exhibit 68 is the personal search memo, so and so. I know Mr. Prem, who I have mentioned in my exam chip, he's no more, as he explained. He was around 50 years old. Because he has not said anything, but we have brought on cross about Prem a lot. But there's one accused called Prem in this case. Was convicted under 20. A junior Prem, but he's a senior Prem. This is just to bring that these two Prems are different. We have just brought this that this Prem has expired. Now, here also, my lord, he has said he was working in Axis. They were getting loan. There was central government aids. And in that only they were operating edges. Apart from this BW witness whom the prosecution relied have not said anything. Part 1, volume 2, my lord. PW 43, case number 273.
Page number?
273, 273. I work as director. I worked as director agricultural government of Manipur and I retired in the year 2000. After my retirement, I joined a private firm called Association for Extensive Growers, AGIS. The said firm is a registered society and it works for food processing plant. The said firm is based in Imphal East. Initially, it started with extraction of fruit juice. I joined as president of the executive so I worked in the said society till the day it was closed by NI. There was an instance of telling me that my promotion from joint director to additional director by superseding few senior while I was in MCI, although the post belongs to the state government, some youth came and asked me not to accept promotion. They even shown some indication that they have arms with them. I told you that my promotion is not done by myself, but by the higher authorities. Initially, as I started from Purana Rajbani, which is also in Imphal, before my becoming president of AGIS, Prajapati was the president and Bhumi secretary, and he continued as such and treasurer A. Gonchas. When I just entered as president, the initial capital AGIS was estimated at rupees 197 lakhs, estimated at 197 lakhs, and later revised to rupees 206 lakhs. An amount of this capital was taken from Imphal Urban Cooperative Bank, main branch, but the same was not utilized and was deposited back within a short period. During the taking of loan from the bank, Prajapati was seeing was the president. During 2005, I came to Guwahati to meet consultant of the project in connection with AGIS. It was discussed. It was a discussion where I met Secretary and Bhumi Singh, Prajapati, which I had some other, which I do not remember. There, the person whom I met was not known to me, but he asked regarding the viability of the project, to which I replied, it is going well. After my return, I continued as president. I again came to Guwahati sometime in 2009 and stayed in a hotel. During that time, also President Singh Ibomsa came to Guwahati and Bhumi did not come because of his illness. During my stay in the hotel, we all met person and simply inquired about the edges. Why Brazil is related to a member of here? Why Brazil Singh? He is accused number 23 here in this. During a basis, my statement was recorded before first class magistrate Kamrup. Exhibit 19 is a section of 164 statement. Exhibit 93 is my signature. Exhibit 94 is a section 25(1) of UAP attaching properties of edges. 94(1) are my signatures. Exhibit 95 is a notice under section so-and-so. Issued to the second Bhumi regarding so-and-so. Exhibit 95(1) is my signature in token of receipt notice. Exhibit 90 is a statement account prepared by Chartered Account and Company for edges for the period of so-and-so, so-and-so, so-and-so. Now, pros. Edges is a society registered under the Societies Registration Act. Edges had submitted a project to the Ministry of Agriculture and Ministry of Food Processing Government of India, seeking funds to the edges. Under the said project, we sought a financial assistance of rupees 206 lakhs. On approval of our project, the Ministry of Agriculture government allotted a sanction rupees 28 lakhs and released the same in favor of edges. Another sum of 50 lakhs was sanctioned and released by the Ministry of Finance. The said amount of rupees was a long-term loan and the others it was purely a grant. I visited Delhi personally to meet official concerned ministries for availing such funds for the loan and loans. I do not know how the amount loan taken from the Impala was managed, but I was told that the same was by way of bookkeeping. By bookkeeping, my lord. I was told telephonically by one DSP NIA of the name Bakshi to come down to Guwahati. I went to the court of learned judicial magistrate Kamrup for giving my statement along with the police officer 100% Mia. While proceeding towards the court, I was briefed by the said police officer about the statement to be given before the magistrate. I was briefed. After recording my statement by the magistrate, I was escorted back to my hotel by the said police and his man. The witness is confronted with a portion of under situation so that now in 2011 I came to know that all the appointed named 3 people have been with so and they invested money of this UNL into this UNL into our scheme of acquisition. And the witness was asked whether he gave such portion of said statement before the magistrate or not. I did not actually say the said portion of the statement to the magistrate. And the witness was asked whether he gave such personal statement and not. I did not actually say the said personal statement to Mr. I cannot remember if the statement or once read over by me or not. I do not know the name of particular member of UNLA with whom presumably was related. No, my lord. What has come out from his examination? That was enhanced from 197 to 206. They applied. The central government has given 20 and 58 lakhs. They have taken loan. He says bookkeeping, but the Imphal Cooperative Bank people say that he says bookkeeping, but the bank personnel says it was written in 14 days time. Now he says that Mr. President has got one relative who is in UNLA, but he doesn't know who is that. Now, from this evidence of PWs, nothing has come out that to fit within the ambit of section 21 of the UAP. This fund has come from central government bank and others from membership fund. My lord, this membership fund, if it has come, this has to have a terrorist link. That has to be for a commission of a terrorist act. That is what the act says. Now, is there anything on evidence, on record, that because of the commission of a terrorist act, this particular extortion was done or money has been paid. Yes, PW 39 says, but he said, no, UNLV has no demand. About imposters. Now, this is what, now, so far, judgment goes, my lord, I respectfully take my lord to the judgment part that my lord will find. My lord, part 1, volume 5, judgment, the relevant portion, my lord, respectfully, I'm taking lordship 958. Nine five eight, my lord, para 20 of the judgment. Our court judgment. Part 1, volume 5.
You see,
My lord.
in this case, for example, let us take PW 45. PW 45 increments UNLF of making extortion and demands. Now, if there's any link between any of these accused persons or appellants with the UNLF, then even one evidence is sufficient to increment under section 20. PW 45, just go through it, you will find. He has given two names, but if UNLF is otherwise, if one can be proved to be a cadre of UNLF, then even one evidence is sufficient to
My lord, PW 45, he happens to be an engineer. Happens to be an engineer. Now, he says there are 7 outfits, among them also UNLF. Now, there was an incident of house of my superintendent so-and-so, training hand grenade, so-and-so, so-and-so, again, so-and-so.
see what I'm trying to elicit from you is that, you see, you are saying that there's no link of these people with UNLF,
My lord.
except for that email. That's your stand. But what we find is that, assuming that some link can be made out by Mr. Das, where you can be shown to be a member of UNLF, then despite all the witnesses saying something, but PW 45 itself is sufficient to incriminate you under section 20. Then it will be a proceeds. If it's a member of UNLF, then the proceeds has to be a proceeds of crime. Because somebody gave that evidence that this Aegis is a front of UNLF. So that's why there can be some link.
My lord. My lord, respectfully, my lord, let's visit PW 45 just for the sake of it, my lord. And your lord is quite able. I'll just read out, my lord. That my lord will have part 1, volume 2. What it says. My lord, I'll just read out, my lord. I'll just skip some portion, relevant portions. During 1980s, critical situation of law and order has been started by the undergone and other factors by way of pressurizing from different groups, parties for extortion. To overcome this pressure, the government department had to respond to the demand of outfit by payment sometimes collected for the solution. There are several outfits, among them also criminal. That is what we came across from few person whom we met. The threatening was done by way of bomb, grenade blast, kidnapping, etc. There was incident in the house of my superintendent engineer Dhanavi throwing hand grenade into the house of squadron of engineers, causing some damages to the house and not casualty to the engine. This incident was due to action demand by the outfit. Again, there were another incident in the house of Ravindra Summers, and so there was exploded in a compound which related to extortion. There was another incident in the house of Ashok Kumar, additional Swenso, exploded in the house. Besides officer, the are also facing similar situation because of the threat by outfit, including UNLF, into extortion. The demands are used like 9 lakh, however, we used to collect from salary and hand over to the groups in parts. In one particular time, one Ratan, who added himself to be a member of UNLF, has pressurized Colonel for the demand of letter. Mr. Nausar was sent by Ratan to collect the extortion money was immediate department to collect extortion because of the threat of life we have developed. Now, my summation here is, some are saying that I'm a member of UNLF. Now, when 161 was taken of this particular PW 45, he's mentioned this. Now, he has mentioned a name that he himself claimed that he's a member of UNLF, one Mr. Ratan. Now, this Mr. Ratan and Mr. Naucha, NI has not done anything to arrest him. It is just a name that is brought in. But who
No,
is this
They are,
Ratan?
they are not arrested.
They are not arrested.
Okay.
Now, may I take your lordship to proceed? He has specifically named two persons who say that they are a member of UNLF. One is Mr. Ratan and one is Mr. Naucha. And they are not arrested. Had they been arrested, it would have been a different thing. But they are not arrested. No, my lord. My lord, I Milord. On cross of 45 Milord. That Milord will find in page 284. Cross of for all accused except so. It is true that there are several underground outfits in the state of Manipur. It is also true that instances of committing unlawful activities by the anti-social elements in the name of underground outfits are taking place in Manipur regularly. We cannot confirm the commission of crimes like grenade blasts, kidnapping, etc. committed by the UNLF cadres. I deny the same that officers and contractors of our department face threats from UNLF relating to extortion demand. I deny the suggestions that the officers and contractors of our department face threats from the UNLF relating to extortion demand. I also deny that UNLF never demanded money or otherwise from myself or from my official and contractors. He's speaking two words.
No, it's a typing error. Because here, the first suggestion would have been,
Yeah,
I denied the suggestion that the officers and contractors of our department did not face threat from UNLF.
Ah.
But otherwise,
No.
part one and part two is totally
That's right.
correct.
It's speaking two meaning, like that's what, my lord. Now,
Because this is a common mistake occurring in the trial courts, because when it comes to writing of two negatives,
sometimes.
it
it's
sometimes
confusing.
happens.
It confused everybody. That's
Uh-huh.
just right.
Two negatives is
No.
a positive, is something which we miss out.
Yes. Now, I do not know Mr. Ratan Singh personally, and sirs, I cannot confirm whether he is a member of UNLF or not. Similarly, I also do not know Mr. Singh, Navjot Singh, and I do not know whether he is a member of UNLF or not. There was no instance of demanding money from the UNLF, but from me by the UNLF. I do not know any of the accused persons now present in the court.
So link is lost.
Link is lost.
Okay.
So 45 link is lost. Now, my lord, I humbly take my lord to the judgment part, that volume 5 part 1.
Para.
Para 20. Relevant pages 958.
Para
Para 20.
20.
Of the judgment.
Yes. Yes.
958.
Yes.
While arguing for A23, 24, and 25. While arguing for A23, 24, and 25, the learned defense lawyers submitted that Aegis was a company incorporated in Manipur in the agricultural sector, and the state and central government extended grant to the company. Just a matter of record. Allegation that Aegis was funded by UNLF and was provided and controlled by it was completely untrue. In this connection, it referred to the testimony of PW 23, 24, 29, 43. And stated that there was no admissible evidence in the testimony of the aforesaid witnesses to suggest that A23, 24, and 25 were engaged in any criminal conspiracy with the remaining accused and were members of UNLF. In the concluding part of the argument, learned defense got become little bit emotional and submitted that in the democratic country, every individual has a right to propagate any political ideology. He however fairly admitted that such ideology cannot be reason for any valid argument or cannot be used to challenge the constitution and sovereignty of the country. Now, para 54 that Millard will find in page 974. If your road is wrong.
Page?
Page 974, para 54.
Yes.
PW 23, the then bank officer in Imphal Urban Cooperative Bank deposed that Aziz had an account with the bank, and on 37/2005, the firm took a loan of rupees 2 lakh from the loan was from the bank, but the loan was fully repaid on 16/8. He also proved several transactions of the firm in the bank. He further deposed the resolution of opening bank account was signed by 8/23, 24, and 25, where the operators of the account. The fact of taking huge amount of loan and repayment with same was short period and was really usual, and spoke loudly about the extreme financial soundness of the firm. Now, my lord. Para 54, PW 23, the then bank officer in Imphal Cooperative Bank has deposed that Aziz had an account with so and so and took loan so and so. He also proved several transactions of the firm in the bank. He further deposed a resolution of opening bank account was signed by 23, 24, and 25, where the fact of taking huge amount of loan and repayment. My lord. Now, para 54, lord, 1, 2, 3, the fourth line from the bottom, para 54. The fact of taking huge amount of loan and repayment of the same within such a short period was really unusual and spoke loudly about the extreme financial soundness of the fund. Financial soundness per se cannot be held to be an offense if legal source of such money is clearly visible. Now, but that was not the case. Let's see the reasoning, my lord. Let's see the reasoning. It would be evident from the testimony of PW 24, who was a chartered accountant, was given a task of to audit the balance of sheet of edges at the relevant time. He deposed that the firm produced the books of account for audit, and A23 also came to the office. The witness for the stated the large number of amount of contributions were not supported by documents, and he found several other anomalies. PW 29, a management graduate, deposed that in the year 2000, he used to work for edges, and during that time, he met A23. 24, 23, and who are in management of firm, the statement PW3 and PW20 indicate that accused A24 were involved in the activity and that the firm is dealing huge amount of money which you are not properly accounted for. One part, my lord. That, yes, humble citizen, my lord. If a registered society's money is not accounted for, can it be assumed that this is a terrorist fund? My lord, can it be just directly assumed? It's just in it, my lord, I'm just giving parts by it. That he said that if the source is not known, okay, in one sense. If the source is not known, is it just a terrorist proceeds? There are other mechanisms, my lord, to find out from where the money has come, because it is maintained in the bank. My lord, even at the stage of framing of charge, my lord, suspicion cannot stay. Well, only when there's a strong and grave suspicion, the charge is normally framed. Here it is in the realm of assumption only. And the conviction is based on the assumption. It's not even a grave suspicion that has come to the mind of the court. Now the second part. What it says in the second part of the assumption, that apart, email, exhibit 190, 191, 92 to the series and 94, retrieved from the mail of A90, my lord. My learned senior has taken my lord to the 65B for embargo, and this is email. And retrieved from A19 RKM again, reveal deep link between UNLF and edges and control your over edges. My lord, can it be a finding based on just an assumption? In the realm of assumption, can someone be convicted without appreciation of evidence? When no evidence has come forward, fine. Let's assume for the time being that there are lots of money in the farm. And My lord, I was one, two, three, four, fifth, two, three, four, fifth line in just above para 55 from the bottom. My lord, now the second part is in this particular para, my lord, two things, my lord. Now, the learned special judge has come to a finding that, okay, having lots of money is not an offense if we can give the source. True. Now, what is the source? They have not produced any evidence. Well, there are other mechanisms, ITA, PMLA, that thing, everything is in it. That money trail is what is the money trail? So without coming to a conclusive finding about the money trail, my lord, because prevention of money laundering, my lord, one of these schedule offense is also unlawful activities to prove the process of crime. In PMLA, apart from IPC, unlawful activities, NDPS, they are the schedule part A, part B, part C, part D. These are all schedule offenses. Well, nothing was done in that respect, just an assumption. And when assumption somebody is convicted, even at the stage of framing of charge, even though suspicion is there, the charge is normally not framed, only when there is strong and grave. But strong and grave, how much that suspicion is strong or grave cannot take the stand of a proof. I want to come. my lord. Variety that, my lord, page 987. How the linkage has been brought, my lord? Variety, page 987. Page 987, variety. My lord, evidence on record have been discussed in the preceding paragraphs. In regard to A5 to A19 and A22 to A25, materials brought on record appear to have indicated positively membership of the accused a band organization, my lord. Indeed, my lord, what have indicated on the membership, on what ground? Indeed, mere arrest of accused A5 to 8 from Guwahati while they are staying might not be a conclusive evidence of their membership, one part. But when their assets and other activities were discussed in the emails retrieved through disclosure made by A18, it categorically established a linkage. Now, the linkage between all these accused to be a member is only through email. That's what the learned special judge has said. The only linkage is through email, not from other things. Now, it categorically established that it has already been found the email in the case of admissible in the evidence as much as the certificate under 65B. Now, why the email has taken on record as admissible that the learned special judge felt that 65B certificate has complied with section 65B4 of Evidence Act. Now the only linkage is email. And now the moment the email goes, nothing remains because there is no finding of other aspect. That's what my lord has said. Apart from email, is there any linkage? Even the special judge has come to the conclusion. Only because of that, my lord, I had to read this para 18. We continue to my lord. Right. Any problem? Any problem?
Lordship. Sorry, I meant, for Lordship, we have item number 22. If Lordship, this continues, it is not possible.
This is likely to continue, but I'm not passing. We are not passing any orders right now, but this is likely to continue. It's going on for 5-6 days today. It will go as leftover.
Daily list, time being item 7.
Contradiction delay, huh? Mr. S. Biswas, counsel for the legal aid counsel for the applicant. And Mr. K. Bashir Lanan, APP for the state. You notice steps by registered post lady. This was 302. As well as the usual process to be served through the jurisdictional magistrate. Notices may be available on
And 4.
10. I contradiction delay. Huh? Okay.
Time being item 8.
You say Mr. J. Das. Legal aid counsel. condition of 87 days. Notice. Step by registration procedure as well as the usual process to be sought through the jurisdiction magistrate.
Item 9 to 21.
Lord, my lord, I was in part one going fine. Part one going fine. Page 97.
Hopefully today, you and Mr. Das would be Bruce Willis in our court. Last Man Standing. You've seen that movie? Last Man Standing? No. No. It's a wonderful movie. So, Last Man Standing.
On the last occasion also, the Lord seems very fond of English movies like Ian Fleming series of channel. I was noticing that.
No, I love to lecture, not watching movies.
But, respectfully, I think, my lord, to part one, volume 5, page 987.
9?
Page 987.
87, okay.
987. I was on para 18. My lord, it has para 80 says about two things. It says, first part, arresting them from Guwahati would not be a conclusive proof to be linked up with their membership or not might be a conclusive evidence of their membership. However, but 1, 4, 3, 4, 5, 6 line it says, but when their arrests and other activities, were discussed in the emails retrieved through the disclosure 18 and 19, it categorically established the linkage. This is the only linkage, like even the special court was on the ground that the linkage is only through emails, but not other evidence. My lord, respectfully, I take again, my lord, to para 82, that how to finding is come in para 82. Para 82, it says, in paragraph 53, 54, 50, that Melody will find page 989, para 82, in paragraph numbers 53, 54, 55 of this judgment, the activities of A 23 and 24 were discussed, vis-a-vis the testimonies of PW 23, 24, and 25. It may be briefly mentioned here that from the testimony of the aforesaid three witnesses and from the emails. Now, 23, 24, 29 has not said anything about the incriminating things against Aegis. They're only on the fund. 24, however, CA said there was some money where they could not substantiate. That is what 24 said. 23 and 29 said about the loan and the aid from the central government. Now, it may be briefly mentioned here that from the testimonies, aforesaid three witnesses, and from the emails, an attachment and various documents exhibited as Exhibit 55, 56, so and so, linkage between UNL AGs was established. Now, how this linkage established, it says from the emails again. It is also found that emails Exhibit 90, emails Exhibit 190, 191, so and so were retrieved from the email ID of A19 who established deep linkage with. Now, even the edges, it's only from the emails. Being in the top management, my lord. Being in the top management of edges, A23, 24 were also responsible for such linkage. But what is this finding, my lord? It's only in the assumption, my lord. There's no evidence to this effect, my lord. It's only on the assumption. Being in the top management edges, we are also responsible for such linkage. From the testimony period, it was clear that there was serious anomaly in statement of the account of edges. As much as regarding the huge amount of money collected, there was no specific mention in the source. Now the next line, it was either invested by the UNLO or was extorted by. Well, is it the way how the evidence needs to be appreciated and that it was either, even he is confused. Even the special judge was not convinced. It was either invested by the UNLF or was extorted for UNLF. He's giving two opinions. It may be this, it may be that. Now, it was either invested by the UNLO, was extorted. All these categories indicate, my lord. How does it point, my lord? It's still in the stage of suspicion, my lord. Even though that is too strong and grave, cannot stand this kind of a proof, my lord. Well, the standard of proof in criminal trial is a different altogether, beyond all reasonable doubts. But here the finding is either it may be like this, it may be like that. It is not even in the degree of preponderance of probability, my lord. Let's forget about it beyond all reasonable doubts. Now, my lord, when the learned special judge has come to a conclusion that it may be either invested by UNLF, maybe invested by UNLF, it was either invested by UNLF or by the UNLF or was extorted for the UNLF. But my lord, what role I am playing now, Aegis? The allegation in the charge sheet is that Aegis is being funded by UNLF. That is the allegation. Now, the finding of the learned special judge is that either Aegis is funded by UNLF or Aegis is there to extort money for UNLF. Well, by the trial itself, he has came in two positions. Either you are extorting money or you are being funded by UNLF. Well, what is this finding, my lord? Is it a logical finding? Okay, fine. If I'm convicted that you're being funded by UNLF, that's a different aspect altogether. And even he's not clear my stand. Either you're working for UNLF or you're being funded by UNLF. my lord. Somehow I fail to understand, my lord, this logic. My lord. Now, again, all these categories indicated Aegis was functioning as overground outfit. Now, now it says because of this factor, I'm overground. So A23 and 24 are were indeed members of UNLF. My lord, to convene me under 20, let's forget for the timing 21. To convene under 20, the membership that I'm a member of UNLF, the first thing, the learned special judge has come to a conclusion that in Aziz there are lots of money, which is source is known. So he has assumed that even though this is an offense, if that source is not disclosed, then directly it also is a money of terrorists. My lord, the lordship is quite aware of the fact that when the money is unaccounted money is lying with me, my lord, there are other mechanisms, prevention of money laundering, this and IT, anything. But how can it is it? Okay, some money is with Gunadhar, so then but fun of terrorists. That is a direct conclusion without any evidence.
Live, we can say that.
My lord,
As this court is live, and you have said that.
no, you don't understand in that manner.
No, not that. It becomes now an evidence.
My lord, that is how the conclusion has come.
It becomes an admission.
This is how the finding is, my lord. Some money is there, therefore is a terrorist money.
Okay, point taken.
Now another aspect. Even though they are arrested, my lord, Aegis members who were arrested from Imphal. Now the special judge has come to, even though they were arrested, it may not be a conclusive proof that they are members of UNLF. Now the first part of arrest in Guwahati and their activities has nothing to prove that they are member of UNLF. If we go by PW 34 also, it's very 33. 33. It's very clear from Yashodhara, who was Ayub. Now, second point is that because of these emails, the leakage is found. Now the learned special just try to fortify it, the second part, saying that 65B4 certificate, the 65B, the amount, the criteria qualification is already complied with. Therefore, the emails are admissible. But when the certificate is read, when 65B4 is read, it's not admissible. If you really go by the provisions of 65B4. Now in the entire case, here even the linkage is by the email only. But a clear finding in para 80 that arresting them from Guwahati or their activities may not be a conclusive proof that they are members. The linkage is only through email, which is not admissible in the eyes of law. Then what remains in the case? If there is no finding of this special judge on that aspect, that he has come to a conclusive finding that by arresting them in other things cannot be a member of the membership cannot be proved. That is only true.
family এটা সাতাইশ ডাঙৰ চোন এইটো সাতাইশ দুটা মিলি এটা দি দিম
My lord, part two, volume two.
That's all I suppose.
My lord, page 368. Part
Page?
two, volume two.
Part two, volume two. Yes. Page
Page 368.
368. Page 68.
Then I Sri Srenso, page 360, this is exhibit 94. I Sri Srenso. Assembles the assertion for extension cross initiative service, along with business structure. Along with represent NIA Manipur, addressing the project in accordance with the provision of section 25 F amendment for conducting the said procedure have obtained a prior permission writing from the Director General Police, so and so, 11/10/11/2021 to 11 for attachment of said property in accordance with the provision and so and so. Now, that attachment person was conducted in presence of the following person who was president, secretary. So attachment was done on 10/2015. In presence of local independent witness.
Yes.
Now it was done, and this particular attachment, in fact, notice was given that will find in page 373.
What is this memorandum? Attachment of property.
Property of edges. Edges, the property of edges.
Yes.
Now, this is how the attachment has been done. And this is when these edges was attached. Then Mr. Bhumi referred an application before the special court, via against the attachment. Now, but this particular attachment was upheld by the special trial court. Thereafter, in 2013, the appeal was moved under 21(4) of NI, 2013. But when the matter was heard, in a very simple, this is a very simple matter, when the matter was heard, it's still a issue of framing of charge, trial is start at time. So when the matter was taken up, matter was posted to be heard after the trial is over. After the trial is over, the matter has been taken up. This is an appeal of 2013 ages. Item number 10 of today's matter. So what, not in a very oral formula, the then justice led by, if I'm not wrong, Justice, His Lordship Justice Vaipai, said once every trial is over, if I get acquitted and all, then automatically this will be, every property will be released. And only on that aspect that this appeal, aegis appeal is there. Once this A23, 24, 25, A23 has expired and 24 has expired, 23 and 25 are acquitted from the charges. Normally, aegis has to go. Because here, so for 25 is concerned, the linkage is nowhere it is linked with UNL. That only in the email, which is not admissible, even though that is not admissible, I submit it's not admissible, even though assuming for the time being that, assuming for the time being, these are admissible emails. But what actually transferred from the email? Nothing has been fixed. Whether the funding is done by UNL or extortion is being done by UNL, nothing is transferred. Of course, there were instances, I have to concede, unless from those inadmissible emails, there's some accounts were called by the UNL to look after this and that. That is there, but that cannot be a criterion to connect me that I'm a member of UNL and to convene me under the membership under 20. But it is clear that central government will not. If the assumption can be drawn by the learned special judge in that line, another assumption also can be drawn because it's being funded by central government. Central government might have verified before it gives grant and financial aid. And before bank loan was given, they would have verified. So only on the aspect that there are certain emails where my name has been mentioned. Even in para 82, it says in the email, some names are mentioned about the arrest. If some X is arrested by the police with Y, who happens to be a member of one underground organization. And if in email says that Y has been arrested along with X, whether X will automatically become member? Because that is what they have done in Londonese matter. Yes, I am the wife of Jiten Singh. But by being a wife of Jiten Singh, how can I be convicted under 20? And how Jiten Singh is a member, that also is not true. Because in the entire matter, in this entire matter, in fact, I would rather submit in this manner that there are certain inherent defects in this particular case. Because when they have dealt about conspiracy para 86, the conspiracy is not defined in unlawful activities. The conspiracy is defined in Indian IPC. Conspiracy is, we cannot have a different meaning of conspiracy in unlawful activities. The conspiracy defined in IPC, that is a meeting of mind. So in para 86, when the court has come to a conclusive finding that there are no meeting of minds of these people, of these accused, then where can we have the meeting of mind under 18 and under 121A? And my lord, now There's also another paragraph that it so happened the preparation was made. What preparation was made, we don't know. The preparation was made, that preparation before it was turned into an A, they were arrested. If we go by the preparation method, it is 122 IPC, that is preparation for waging war. 122. And everybody was charged under 122, my lord. And surprisingly, my lord, only R.K. Megan have been convicted under 122. Huh? Huh? And nobody was convicted under 122. Then, Widom R.K. Megan was preparing 2 ways, what if at all, even though he has not filed any appeal, then it cannot be this other guy. They have convicted R.K. Megan under 122, but that 120 was also charged against me, against everybody. Now that for preparation for waging war is only against R.K. Megan with, not against with any other. Then we do R.K. Megan was prepared. We do R.K. Megan was meeting the mind. Then none. If R.K. Megan has been taken out separately, then we have to be taken separately. And now, from where they have come to a conclusion of R.K. Megan, my lord, I respectfully take my lord, even though he is not on appeal, my lord, let me just for your time perusal of your lordships, PW 3 and 4, my lord. I respectfully take my lord, part 1, volume 1, that my lord will find PW 3 in page 162, my lord. Part 1, volume 1. My lord. They are
Mr. Mishra has referred to this.
protected evidence. Why
Mr.
am I
Mishra.
referring to this? My lord. If I take my lord to page 163, 120 from 39 from the bottom. Now. 122. Lord, may just read out loud. I think they had a small parade ground that 13 from the bottom allowed. They had a small parade ground. The cadets gave guard to 163 base number. They had a small parade ground. The cadets gave the guard of honor to Chairman UNLF and sang some songs. There were 13, 14 cadets who gave guard of honor. After that, he came to our group of journalists and introduced himself as Sanayam, chairman of UNLF. We were filming the camp and surrounding places. He spoke informally in English with the journalists. We interviewed him. He was interviewed by my colleague. The interview was about asking about the struggle of UNLF against the Indian Army. That was their objective. What was their objective? Interview was about asking about the struggle of UNLF against the Indian Army. What was their objective? What was to achieve about their demands? We asked him about the rationale behind their armed struggles. He accepted that there was conflict between the UNLF and the Indian Army. He accepted that there were casualties on both sides as a part of their conflict, and he claimed that Manipur has been an independent state. That was the basis of quays for their independent state of Manipur. My lord, even here, for the timing, assuming that we'll take this as a credible witness, sterling witness, 3 and 4 for the timing, even what in their interview, what R.K. Megan has said is that he wants a plebiscite by the intervention of United Nations. When somebody has expressed that he wants a plebiscite with an intervention of United Nations, my lord, nothing is about, my lord, if we go by 121A, my lord, even though that is not applicable in this case, using of criminal force is not mentioned, my lord. He's just wanted, I want a plebiscite, I will lay down my arms. If intervene, I want a plebiscite. Plebiscite is a democratic form, my lord. In the last line, he would like United Nations plebiscite. This is his intention. In a very democratic form, my lord. And so far, PW 3 and 4 is concerned, my lord, that particular, my lord, my learned senior also has taken your lordships to this particular 3 and 4. However, my lord, just in addition, my lord, my humble submission of this PW in 3 and 4 is the particular interview which they said, which was telecast, which was in their office, was never seized, my lord, and it was never produced. PW, let's believe them for the time being. They've categorically said these films were never seized by the NIA. So what is that interview about then? And even if we take the interview for the time being, then it's not a criminal form, it's a plebiscite, a democratic form. Plebiscite is democratic, that voting will be done by the public. And what this interview, they said that it was telecast, and even they have not said anything about this. And they said that it is lying with them. The edited interview is lying with them, not the original, but still the edited has not been seized by NIA. Why? Whether it was really telecast or not telecast, whether it was an interview or not, nobody knows about that. They were protected without disclosing their identity, they were examined. But what could prevented the NIA to seize the edited electronic documents that was telecasted? That's my humble submission, my lord. So the link up that your my lord has said, PW 39, Robert, PW 45, Indramani, PW 3 and 4, protected witness. Then 3 and 4 has been heavily relied on by the learned special judge. And the rest is 39 and 45. 39 has no place, 45 also gone, my lord. 3 and 4, what interview they have done? They said they have edited, they have telecasted. Then all what we were McGinnis said, in assuming that you said, is a plebiscite, democratic form, not the criminal force. And he never said that with the criminal force, I'll overthrow the Indian government. No, he said, I want a plebiscite with the intervention of United Nations. And still 3 and 4 cannot be relied upon. My lord, with all this evidence, the prosecution have miserably failed to link up the chain and to make a complete chain. And they have failed to prove beyond all reasonable doubts, my lord. So all these appellants before lordship are liable to be acquitted. And moreover, just my humble submission is, most of them, except Andoni Devi, who is a female, and there's also nothing against her also under section 20. She was all these appellants before lordship have languished behind the bar about 7 years. Some 7 years, some 7, which I can give you the exact days. I'm making a chart, my lord. There I'll mention everything for your kind perusal of your lordship, my lord. With this, I'll conclude my argument, and I beg leave of the court to reply when my learned senior gives his reply, my lord.
Today or some other day? You will start today or some other day?
start today, Madam. As your lordship, Monday, I think your lordship is fit.
And then we will prepare that chart. It's easier for us.
Basically, here you also will confine to, one is oral evidence
Pardon me?
supported by oral.
No, because you see, we have, what we understand is, let us say PW1. PW1 has exhibited 10 documents. So in that column, if you can mention 10 documents, and the, supposing, for the purpose of accused one, you are relying on 3 witnesses. You can mention PW1, PW20, PW40, like that, and give the, in the next column, give the page numbers where their evidence is lying.
Alright.
We don't want any narration, just to link up. So PW, there is the accused number 1. There are 3 witnesses against him. And then these are the documentary evidence and these page numbers.
Yeah.
So we'll then find out from the papers.
Yeah.
Otherwise, it's very difficult to continuously scan through all these 5 or 10 volumes.
Yeah.
So that is what basically we want. And then the if there is a reference to any document, the document exhibit number and page numbers.
Definitely, because, without specifying the page number and the volume number, it will be very difficult.
Really very difficult.
Very difficult.
Huh. So only that much.
Huh.
We don't need any, we do not need any narration.
Yeah.
We are taking notes of your argument. If you want to file separately, you can do it, but narration is not required for us. We only need the chart so that in one page we can understand what the matter is about.
Actually, you also will also require the judgment paragraph where it is dealt with, side by side. No.
Yes, it will be easier. So if accused number 1 is convicted in paragraph 40, 42, and say 82, if you can only mention that, only that much, so that we can understand easily. It will be a great help to us, because otherwise,
Well, yes.
lifting of 10 volumes
Very-
is again difficult. And I'm a weak man. And I just told my brother that you are an avid sportsman, very agile. We will not be able to compete with you when it comes to lifting of volumes.
We'll try to come with you. Because the thing is that, the case of, documents are voluminous. One thing, what I wanted to do, and my friend is here, Manoj. Not an argument, Manoj, 800 document. Well, your lordship, I remember your lordship has remarked how the emails were placed. It is not a question of what you call Manoj, admissibility. How it was placed, whatever. Because what we find from the paper book, the exhibit, etc., honestly, we find something, only the printed copy, etc. Originals are here. And it has supplied to the defense counsel, they have not traced anything. This is where your lordship will find just one page, just one page, your lordship. The Manipuri version and the translated version, how it was placed before a track. And original will be here in the trunk. There is a big trunk. You find page 42. That is the Manipuri version email.
This is also a printout.
And the next page is the translation translation.
This we can explain. That email was proved by which witness?
74,
PW 74. PW 74 will be volume 4. Yes, just come to page 53. Just come to 53 once. It is at page 302.
That is so.
Correct. In 30, you skip over and come to page 304. You're there? 304, yes. Now come to 115. Exhibit 115 are the printouts of email from email account green plate so and so. Exhibit 115 by 1 is my signature, which appears in email marked E1, and 115 2 is the signature. Now, please come to this document. 115 was
part 2, volume 2, page 422.
422, yes.
422. Part 2.
Yes.
Part 2, volume 2.
Part 2, volume 2. Page
422.
492. Yes. So see, this is page 422, exhibit 115 is the translated copy.
So this is what the translation portion is.
So even if you have presented before the court a Manipuri transcript
One quote as
of email, but that was never proved. None of the documents which is marked as exhibit here, like Mr. D.K. Mishra has shown on that day, because I asked him this question. And he says that all are English. That was his statement. And he has referred to compilation 1 and compilation 2, where he has given photocopies. And then his categorical statement was that no Manipuri dialect email was
exhibited.
exhibited.
But what happened, Manoj? At a time, because this is how the emails were.
So it may have been done.
No, all the documents were, these original documents are there in the box. Now, what has happened, Madhu? At a time of exhibiting the document, the time could says that what we do with the Moriba person. Can I admit it? What we do not understand anything. When we do not understand anything, can I admit it?
Why not?
No, that is what.
No, because you see, number one, let us assume one thing. I give absurd examples. This is one. You see, I don't know anything about guns. I'm a what you call a district judge taking up a murder weapon, murder, and the material exhibit 1 is the revolver. I do not understand anything about a revolver. Should I say I won't admit it in evidence? It's a weapon of offense. I'm not required to know it. Because you see, when under the CRPC, when the court does not understand the language, then it can use an interpreter.
That is fair. When the understanding language is there on record, we accept it and we.
But then
ask
the original evidence is lost.
That's good. And we ask the defense counsel whether what we do about it.
No.
They said that there is no objection. So that is how it has gone on record.
But then it was the duty of the prosecution that they will prove so and so, because you see, expert was there. Expert was there. Expert was said that, yes, I did the translation and this is the correct translation, and therefore both are admitted.
One who translated was never examined.
No, that's okay, but experts are there. Somebody may come and say that, yes, this is the original one, it means this.
What was, my lord, my humble sir, what was retrieved is Manipuri language. What is produced is translated. Oh, my lord.
Just a moment. You see, you have Evidence Act with you. Just giving one copy of Evidence Act.
Evidence.
We have it, okay. Now you see, come to chapter 4, starting with section 59.
Yes, proof.
Yes, proof of facts by oral evidence. So all facts except the contents of documents may be proved by oral evidence.
Except, yes, except all.
Now, there is an implication. I'll just say it and then I'll tell about the implication. You see, the highlighted part is contents of documents is not by oral evidence. Now, 61, proof of contents of document. The contents of a document may be proved either by primary or secondary evidence.
Primary or by secondary.
Now, 64, Proof of documents by primary evidence.
Proof by primary evidence, except in the case here never mentioned.
Yes. So this is 65. Is hereinafter mentioned. So this the document which is not known to the court is not an accepted document. So therefore, what happens is that read 59 as well as 61 and 64, then you will find the sequence is that the primary evidence is proved and then the secondary evidence of its contents can be led. So therefore, English translation would come as a secondary evidence to prove the primary document. This is what I understand, subject to how you convince me otherwise.
Your Lordship, have this paper book part 1, volume 5, my lord. Just 1 minute.
Part 1, volume 5.
Page 1093. That is an order of the
Part 1, volume 5,
1093.
1093.
1093.
Yes.
Learned counsel for appellant have submitted a list of 58 documents stated to be in which are in Manipuri dialect. It is stated at the back that these documents are required to be translated in English for preparation of paper book. The further submitted translated version of the rest of the documents in Manipuri dialect is already available on record in the LCL, and as sustained, retranslation of the same is not required, as they would rely only on the translated version which are readily already available on record. Learned counsel for the appellant submit that they would themselves translate the document in English and submit the same to the registry on or before 2nd November 2013.
Doesn't mean that we're admitting the.
You see, in Evidence Act come to 165, section 165.
Sure.
Evidence Act. Yes, you see judges' power to put questions or order production. You omit the substantive part, then proviso. First proviso is provided that the judgment must be based on facts declared by this act to be relevant and duly proved. This is very important. Provided that the judgment must be based on facts declared by this court to be relevant and duly proved. Correct. So keep in mind this section 61, 63, 64. Keep in mind in the back of your mind, this three provision. Now come to second proviso. Provided also that this section shall not authorize any judge to compel witness to answer any question or produce any document which such witness would be entitled to refuse to answer or produce under section 121 to 131, both inclusive, if the questions were asked or the documents were called for by the adverse party, nor shall a judge ask any question which it would be improper for any other person to ask under section 148 or 149. Next, this is very, very important. Nor shall he dispense with the primary evidence of any document except in cases herein before accepted. So primary evidence cannot be accepted. We could not have dispensed with. Because now when you find the power of the judge does not have the power to dispense with the primary evidence. And therefore, original emails in Meitei language could not have been dispensed with, and reliance of the prosecution to the documents, which is a translated copy of the email. You see, it loses the character of an email. You write a letter to me addressing Bhale Asene.
Right.
Correct. There's a single line message you have sent. Now, To produce before the court, you produce a translated copy. Are you okay? But then you see this, are you okay is a translated copy in a paper, which is not your original message by mobile which you have sent me. So original transcript is never proved. What is being proved is a secondary evidence of something of which the translator is not before the court. So dispensation of primary evidence, that is something you'll have to address us. Because if the court does not have the power, then evidence which is incorrectly admitted can still not become a part of the order, because the first proviso which says judgment must be based on fact duly proved. That is first part. And second is that the document, if it is improperly admitted, it leads to a what you call the judgment being vitiated by perversity. And therefore that itself is a ground to interfere in the appeal. So you are hit by both sides. Please address us on the next date. The submissions of Mr. N.G. Singh and I counsel for the appellants is concluded. Comma reserving right to reply. Mr. D.K. Das, senior counsel, assisted by Mr. D. Bharadwaj. No, first to write Ms. L. Devi, learned CGC appearing for the respondent number 1, and then Mr. Das, senior counsel, assisted by Ms. D. Bharadwaj, is instructing counsel, are present. List on Monday as part of it.
Take my book.
Yes, definitely.
Monday, no? Monday the election will be 5 to us.
Because if you don't hear it day to day, we'll tend to forget.
Yeah.
Because once I start hearing another matter, then most of things will be wiped out.
Whole effort goes.
Huh?
Whole effort goes, mother.
That is what I think. I may be wrong, I don't know. Or second option is always there, I am not smart.
Well, when Millard can tell all the sequence of James Bond series, I don't think Millard will forget that.
No, because you see, everything fits in. Like. Yes. That's only one. Two. Three. Four. Four. Because if it comes to logical sequence, then if I maintain a continuity, then I understand. Otherwise, there's a tendency to forget.
And from this case, Millard.
And we don't have only one matter to concentrate.
Yeah.
So that there lies the difficulty.
And we have also learned lots from this matter from UK research.
Jonas will have another round with this 65B. 65B, madam. Because that is again a catch question, because even lately, I think 2022, Supreme Court has said that this matter is still diluted and sent for attention. If you're watching, I can just pass on the.
Just say that.
Very interesting matter.
Just give me the citation or the party's name. Is it that Pandit Rao?
There is a December 2027 as.
No, name is Pandit Rao. Second name is Pandit Rao.
Oh, yeah, yeah.
Pandit Rao, huh? We've gone through it.
That's it. It's a wrong judgment matter. It only says about that requirement is furnishing a certificate copy, what called certificate. In the conclusion part, you This is of 2010.
Just one. So, Mr. Das, if I have understood this correctly, reading it after a long time, basically there are 2 points decided here. First is that this judgment still reaffirms that a certificate required under section 65B(4) of Evidence Act is a condition precedent to admissibility of evidence by way of electronic record. But there's a circumstances in this case. What happened was that a person had asked for a certificate. It was never given. And it is in that context that the Supreme Court is making is deciding that in a fact circumstances where requisite certificate has been applied for from a person or authority concerned, and the person or authority either refuses to give such certificate or does not reply to such demand, party asking for such certificate can apply to the court for production under provisions of so and so. So now what happens is that let us say that a defamatory news article is published in WhatsApp or it's in Facebook. Now you ask the authorities of Facebook to give you this article, and they don't give you this certificate. You have downloaded it in your computer. Now you are asking them for a certificate, and they are not providing. Then this, if I am understanding this correctly, then this says that you can ask before the court to direct those persons to produce the original. And now if that original is produced, then it is not required to be supported by certificate.
Okay.
That is what I understand.
That is, no, that is one part. The other part is that the judgment says that certificate is mandatory. It should be fine. That's all right. But the conclusion part is says that you make a rule how it is to be given, because the attack here in this case 150 I think 112 and 112 and 100 and I think
15.
yeah, these are the two certificates. We say the certificate is given in this case and it's all right.
No, your
Uphold-
certificate, you see, Mr. Mishra has attacked your certificate on the ground that it merely certifies downloading. It does not certify what you call uploading. And you see, the second part is there's another part.
Okay. But the section says that, yes, once you download it, you give a certificate. It doesn't say anything more.
No. Here you see what has happened was the reason why Mr. Mishra was attacking it was that the computers and laptops were present, were there. And this man gave you the passwords. From that passwords, you see, supposing an email can be that my court master, if I give him the password, he can open my email account. But that was not done. What happened was that they took the passwords, went to Pune, and then in that computer they downloaded, and then from that computer it was transferred to a hard disk.
We'll read the evidence again. Everything was done at Delhi NI office.
Huh.
At Delhi NI office.
Delhi NI office.
In presence of the accused.
No, there are two places. One says Pune, one says Delhi. That Seagate hard disk went to Pune.
Yes. One was done because the accused was.
Yes.
Go through the evidence.
You see, now what is happening is that supposing there is an email, correct? If that email is to be downloaded, it can be downloaded in any computer and printout can be taken. But that procedure was not adopted. The people went to Delhi office and then the printouts were taken there. The certificate does not support printouts. It supports only downloading. Then all these things were stored in a hard disk. And then this hard disk went to Pune. Chandigarh. Now you see, what happens is that and those were also proved. Now, first of all, there is first downloading at a computer which is not accessible. So therefore, only certificate of downloading is given by that. So who did the printout?
We'll go to the.
Huh. Then there's another part. You see, if that was a primary evidence,
What I recollect. my-
there's no requirement of downloading everything in a Seagate hard disk and sending it to Chandigarh to have a certificate that it was the correct untampered.
That is a letter. That is subsequent. Step. What happened, Malo? That's what, will go to the record. One second. There are two accused. Accused number 18 and 19. From 18, after getting the password, download was made. Again, from 19, password was asked, download was printout was made. Now the question, after getting the mail, they transfer it to what you call hard disk. For the purpose that to get a certificate from Chandigarh, that is expert, that whether to see that these emails are correct or not, only for that purpose. We'll come to that, but we'll just go to that. So, when printout was done at Delhi itself, whatever printout was done, because there are 2,000 copies, printout, etc., and all this. So whatever it was done, certificate was given. That is what I want to say. We'll just, that is the only question of Singh. What I say, that is a different.